It's done.
Okay, brilliant. So I will log off, Mr. Bashir. If there's any problem, please text me.
Yeah, I believe there will be no problem because the net connection now is better than before.
Yes, yes.
I have the 4G connection, so it's more fast, more secured, and more expensive, but this is business after all.
Very good, very good. Excellent. So everyone, my sincere apologies that I can't, join you guys. I've got to be in another place at the moment, but I'll try to join tomorrow. Enjoy yourself. Take care. Bye.
Okay. Bye. Good morning, everyone. My name is Bashir Nakib. I'm GRC consultant AML and same time founder and CEO of Compliance Alert. Been in the banking arena since 1975, been in Doha as consultant supervision team for Qatar Financial Center Regulatory Authority. Did some time with ICBC, the Industrial and Commercial Bank of China. This bank, the Chinese bank, has been top list with the most global banks #1 ranking. Did some services to Royal Bank of Scotland, Goods and Co, and for certain insurance company, insurance and reinsurance called SEAM, cooperating with certain technology, more advanced technology company in the field. This company is now based on the offshore center in Doha under QFC authority called Valores Compliance Integrity. Valores Compliance Integrity very recently signed an agreement, MOU, with Qatar Islamic Bank, which is the second largest bank in Qatar. And we are covering this IT, AML consultancy, risk management, all those issues. Our today presentation about the GDPR Global Data Protection Rules and Qatar Data Protection and Privacy Standard. Today's session, the purpose of this session is to help you understand the key elements of the EU General Data Protection Regulation, GDPR, and how you will need to prepare for implementation of the Qatar new data protection law and privacy law. The content, what's meant by data protection, the risk of breaking data. The risk of breaking data protection regulation, guides on how to identify different types of information, practical tips on effective safe practices, what to do, what to go for support, and how to report a breach. The outcome of this webinar training, you will feel confident in your role and handling different types of data. You will understand the boundaries on using data. You will be able to implement measures to ensure security of your data hold, and you will know where to go in data protection and data privacy. Consider asking yourself this question: are we taking all reasonable measures to mitigate the risk by leveraging global data that is accurate, reliable, timely, robust, and verifiable? Does our data bring together corporate linkage and beneficial ownership? Can we get to this data quickly through modern delivery channels? Can we leverage analytics to understand direct and indirect relationship, handle looping control, and support all endpoints? Are we using master data and automated intelligence to create a data-inspired compliance program? The AML KYC, anti-money laundering KYC, and personal data. AML regulation requires the collection, processing, and analysis of large volume of personal data. The aim preventing the financial services industry, and now non-financial services as well, from being exploited as a means of laundering money and committing financial crimes. While the data protection regulation places restriction on how and when and why personal data can be collected, processed, and used, it broadens the definition of personal data, bringing all information collected under the AML regulation directly within jurisdiction of data protection. We are living now, because of this, in two words, AML and data protection. In an exemplary KYC scenario, a business would be able to know without a shred of doubt precisely who the client or customer behind every single transaction is CDD. CDD, it means we perform our customer due diligence in every single customer client we are dealing with and about his customer, which meant KYCC, know your customer. The AML rules require collection, processing, and use of personal data to comply with regulatory obligations. Mainly now in Qatar, we have in September 2019, the Qatar law number 20 of 2019 about fighting money laundering and combating terrorism financing. In the same time, we had by December 2019, law number 27 out to fight terrorism. By end of December 2019, Council of Ministers issued regulation, regulation number 41 about the executive implementation of law number 20 for 2019. Why? Because this law, because this law doesn't cover only the financial services, but also cover designated non-financial business professional, which means any profession, any business which is not financial business falls also under this new law. So under the AML rules, the collection, processing, and use of personal data to comply with regulatory obligation covers customer due diligence transaction and behavioral monitoring, internal and external data sharing, including with the group's regulation and other financial institutions. Data sharing for outsource arrangement, cross-border processing for data, example given, the processing of international payment. Data protection is very focused on minimizing what data is collected and justifying the purpose for which it is collected. A balance will need to be struck. Customers will need to be advised that data is being collected from them and about them, and will be analyzed, stored for the purposes for complying with AML without a right to be forgotten. The data may also be shared without the customer explicit knowledge with Financial Intelligence Unit, the FIU. In Qatar, we have Qatar FIU. The Qatar FIU exists because flow number 4 of 2010 and flow number 20 of 2019. The role of the FIU is to receive all suspicious transaction reports from financial services and non-financial services about suspicious activity connected to money laundering and terrorism financing or fraud or financial crime. And the FIU role is to analyze this kind of information and send it to law enforcement agencies and to Qatar Central Bank for further follow-up by the General Prosecutor about certain crimes. Now, we have the FIU unit, law enforcement agencies, financial regulators, and other entities associated with the processing of payment, provided that the customer explicitly consents to the payment transaction. When the customer consents, then data sharing is happening. which means you have a customer who want to send it a transfer outside Doha. By signing the application, he automatically consented that his data to be shared with other parties. What is Qatar data protection? Data
Mr.
protection.
Bashir, excuse me, Mr. Bashir.
Yes.
Mr. Bashir, sorry, I haven't disappeared yet. Just wanted to remind the participants, please bear in mind that we are doing this as a discussion. And Mr. Bashir, for Mr. Bashir, it will be very helpful if you trouble him with more questions, because he has a lot of answers throughout his years of experience, which you can, learn more from. Please feel free to ask questions. Thank you. Thank you, Mr. Bashir.
Yeah, thank you, Malawan. But asking question will give you the attendee a window to ask question in certain areas or all areas. But if you ask question during my presentation, my webinar, then we'll exceed the 2 hours. Online training will go up to more hours, and this will be, I believe Malawan will charge you for the extra hours. It's up to him. Anyway.
Don't worry, Mr. Bashir.
Anyway, data protection refers to legislation that is intended to protect the right to privacy of individuals, all of us, ensure that personal data is used appropriately by organizations that may have it, what's called data controllers. So personal data is any information that can be used to identify a natural person called data subject by name, by date of birth, by address, phone number, email address, membership number, IP address, photographs, etc. Information are defined as special categories of person data and require more stringent measures of protection. These categories include religion, ethnicity, sexual orientation, trade union membership, medical information, and so on. Although not listed as special categories of personal data, the following are also awarded additional protection: criminal data and children data. The data protection law information life cycle is about data protection by design and by default, called data protection impact assessment, DPIA documentation. It will start by retention period, right to ensure portability of third party, data minimization, privacy notices, privacy right, obtain consent, appropriate use consent, manage consent, restricted international transfers, and safe and secure restricted access, data inventory, subject access request, contracts with data processors, and data breaches. It goes like this: the information life cycle from assessment, capture, store, use, and destroy. And destroy because you have to destroy this data as per virtue of law after 5 years. And this doesn't contradict with law number 20, because law number 20 says keeping records, suspicious records, and records of customers who are implicated in money laundering and terrorism financing for 10 years, and it goes beyond 10 years if there's suspicious activity going on with the FIU. And the law number 20 of 2019 stipulates that it has primacy all other laws in Qatar, which means data protection law and privacy for 5 years, while the law number 20 of 2019 about AML and CFT stipulate 10 years. So we apply the AML law number 20 about record keeping in case there's suspicious activity or similar activity filed to the FIU and law enforcement agencies. What is Qatar Personal Data Law number 13 of 2016? The law number 13 of 2016 sets out a number of potential monetary penalties for violation up to a maximum Qatari riyal 5 million, which is equal to $1.4 million. Not 1.4, but 1 million. It has new safeguards that define data processing similar to GDPR. We said that GDPR is a global data protection regulation issued in Europe. It has the right of individuals, the responsibility of the controller, prohibition to process sensitive data, cross-border transfers, penalties up to 5 million Qatari riyal as mentioned. Individuals make complaints with the Ministry for investigation of alleged violation of the law, who in turn may issue rectification orders as appropriate to controllers or processors, and or seize materials and otherwise document any such violation. So it's about being open with people about how we use their information, not keeping their information longer than necessary, making sure it is accurate. Here, not keeping their information longer than necessary. I mentioned law number 20, that when this is necessity to keep it, we'll keep it as per this law for 10 years. Making sure that data is accurate, making sure that it is safe, knowing that what information we have got and what we can do with it. Example given, the sharing issue, because data protection refers also in the previous slide here to sharing. If you remember, cross-border transfers. Cross-border transfers, it's about sharing information over the overseas, and recognizing a breach and knowing what to do with it. Under data protection, we have controller, we have processor, we have processing data and personal data. Under controller, a controller is a natural or corporate person who individually or jointly with others determines the methods and purpose of processing personal data, the why and how we process the data. This is the job of the controller. The processor is natural or corporate person who processes personal data for the controller. This is the public authority and the agency in GDPR. The processing data is defined as one of several processes for personal data, such as collecting, receiving, registering, arranging, saving, preparing, amending, recovering, using, disclosing, publishing, transferring, blocking, deleting, or canceling personal data, whether or not by automated means under Article 2 of Qatar Data Protection Law. And the personal data is about data of individuals who identify as specific or reasonably identifiable, either through such data or by combining it with any other data. More factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. If I'm going too fast, please tell me. If I'm too slow, also please tell me. The Qatar current legal framework is called about, we have Qatar Constitution, sanctified of human privacy. We have the Sharia law. We have the penal code, non-disclosure of information and image. We have the banking law, protect confidential information by Qatar Central Bank for clients. We have telecommunication law, protection of consumers' information. We have labor law, record keeping obligations and employee. We have cybersecurity law, sanctioning the use of information network, e-commerce law, control on e-commerce service provider all fall within the privacy protection rights, and we have a free zone in QFC, Qatar Financial Center, applying EU data protection directives 95/46 and EU GDPR. So in Qatar, the current legal framework, we have the national law about privacy protection rights distributed among those authorities, the Qatar constitution, the Sharia law, the penal law, the banking law, telecommunication law, cybercrime law, and labor law, and e-commerce law. At the same time, on the free zone level, offshore center, Qatar Financial Center Authority was created, established by virtue of law in year 2005. They apply EU data protection directive because the free zone go up to the international level, international standard. And as mentioned to Malavan a couple of minutes ago, that in QFC system, data protection rules goes back to 2005. Because it's international standard dealing with rules and regulation and laws, now this free zone QFC applying EU data protection directives number 95/46 and EU GDPR. Rights of data subject. Right to what? Withdraw previous consent, object to the processing on the grounds it is unnecessary, excessive, discriminatory, unfair, or unlawful, or request for correction and or deletion, example where there is no justification for keeping such data, access and review, and being informed about the processing and or any disclosure of their data. The right to be advised about purpose of the process, data breaches, and right to obtain a copy. This is the right to be forgotten, not explicitly. No right of data protection and profiling. So this is the right under data subject. Data controller obligation, we spoke on the previous slide here about data controller. So data controller obligation, processing data lawfully, transparently, and fairly under Article 8, 9, and 10. Purpose of limitation, Article 9.2. Data minimization, Article 9.3. Accuracy, Article 9.4. Storage limitation, Article 10. Integrity and confidentiality, Article 8.2, 8.4, 11, 13, and 14. And record only for the competent authority under Article 18. The special personal data, sensitive data, a permit from competent authority is required before processing personal data of a special nature, such as racial or ethnic origin and religious affiliation. Children, physical or mental health, criminal offenses, no mention about genetic and biometric. While the EU GDPR mentions genetic and biometric, the Qatari law doesn't highlight this area. Website targeting children must post notices advising what data is being collected and how it will be processed and used. Obtain parent guardian consent to processing child data, comply with parent guardian request for information or to remove, erase, or cease processing if requested by parent or guardian. And participation in games, prizes, or other activities cannot be conditioned upon providing personal data. No age limit between 13 to 16 years old. Future challenges implementation process for the ministry, create effective data protection assessment, establish processes and procedure to implement and enforce the law, create awareness of data subject and companies. For the companies and other institutional body in Qatar, comply with the general principle of the law, evaluate the impact of GDPR and Qatar personal data and personal law, privacy law, and on the processing activities, collect consent when it is appropriate, segregation types of data, record the process, and implement security safeguards. How to comply? We have preliminary steps, assess the current situation, where we are now, why do we process personal data, the purpose, and how do we process this data. Identify areas for improvement, decide what to do, what do we need to comply, and define steps, where do we want to be, analyze how your company moves from 1 to 3, how to get there, do it, audit, assess, coordinate, and implement. So we go the steps between 1 and 5, assess current situation, where we are now, why do we process personal data, the purpose, and how we process the data. Identify areas of improvement, decide what do you need to comply, and define steps, where do we want to be. 4, analyze how your company moves from 1 to 3 and how to get there. And 5, do it through the audit, internal audit, external audit, the assessment, coordinate, and implement the steps. Example, activity of the company product. We have data type, personal data, sensitive data, shared processors, third parties, the purpose and location. Under activity of the company product, we have online magazine, oil and gas, airplane company. Under data type, personal data, sensitive data, we have IP address, employees' personal data, including fingerprints, and passengers' data. Shared processor, third party, all online magazine is shared. Oil and gas employee personal data, including fingerprints, is shared. Airplane company personal data, passengers' data is shared. The purpose is to deliver the magazine, the oil and gas to monitor their activities, check in and check out, and under the airplane company category, their purpose is about to travel. Without sharing data, you cannot travel because this data to be shared between 2 airline companies, customs authority, airport authorities, and so on for better security. On location side, the all online magazine, we have EU shared parties. Outside the EU, oil and gas location is in Qatar, and airplane company, Qatar, EU, US, worldwide location. Wherever the Qatar Airways goes, we have a location. Practical compliance tools. Number 1, assess your processing and identify the required safety measures to protect data. 2, implement data protection system, ensuring adequate protection of personal data. Identify a lawful purpose to process personal data. Inform data subjects about the purpose of processing and their rights, and request consent if needed. 6, provide data subject with privacy notice, information on purpose of the processing, data controller and processor, and others under Article 13 and 14. 7, sign a processing agreement with your processor. 8, include a binding and enforceable clause of data protection clause in all contracts. 9, transfer data only in accordance with GDPR, standard data protection clauses, binding corporate rules, and codes of conduct. In every single business, in every single company, we have code of business, code of conduct, and code of ethics rules. So personal data practical compliance tool, we have to take those codes into consideration. To go further, designate a qualified data protection officer or a compliance manager. Keep record of your processing activity, prioritize your actions, organize your internal auditing process, be accountable, make sure to comply and to be able to demonstrate compliance, and report processing of sensitive data to Ministry of Telecommunication. Now, General Data Protection Regulation or GDPR. On 5th of May 2018, new stronger data protection laws came into force across the European Union. These new laws affect any organization operating within the EU or holding information on citizens of the EU. What changes with GDPR? Essentially, GDPR increases the standard organizations are held to when collecting data. Legislation increases standard for how we confirm people consent for us to be collect their data and how we make sure people understand what we do with their information. Will this EU regulation be relevant to Qatar data protection and privacy law? GDPR has been enriched in UK law through the Data Protection Act of 2018. This means it's not dependent on the UK membership. The EU will be therefore still be relevant following the Qatar data protection law and privacy law. What are the consequences of not complying? Within the Qatar data protection is enforced by Ministry of Commerce and Industry, regulated by 2016 data protection law. The Qatar Financial Center has its own separate data protection regime in 2005. Qatar Data Protection Law number 13 of 2016 came into effect in 2016. It was not drafted with GDPR in mind. The Data Protection Authority contemplated in the law has not yet been established, and the associated regulations have not yet been established. Under the Qatar Data Protection Law, processors have an unqualified obligation to notify data controllers of a breach type event. Whereas there is a maintained materiality consideration, serious damage beyond data controller, and would be required to notify data subjects and data protection authority. Associated penalties include fines up to Qatari riyal 5 million or US dollars 1.3 million for processors failing to notify, and Qatari riyal 1 million or USD 2.6 million for data controllers failing to notify. On the assessment level, data protection and data privacy are changing because of the world. Data protection and data privacy are changing because of the world is different place with much more technology since the Data Protection Act was introduced in 1998. This is true or false? I need your feedback.
True.
What?
True.
True.
Yeah, it's true.
Okay. It's true. General Data Protection Regulation is legally adopted within EU member states from?
It's 25th of May
Sorry?
2018.
Yes, correct. Now, do UK organizations have to comply with the General Data Protection Regulation following the Brexit? Yes or no?
Yes.
Yes. And the purpose of General Data Protection Regulation is to protect a company financial information. This is going so fast. And The public's personal information, computers, and being hacked. So the public personal information is the main issue.
Yeah.
Under the assessment, general data protection regulations, law setting out how data must be handled, and uh, general data protection regulation applies to data held on computers. This is false information here because the issue here is what? It's not correct information, it's false information. On the assessment level, general data protection regulation is a law setting how data must be handled, and general data protection regulation of data held on computers is false. We have completed this training. Now, what is privacy? Privacy is limit on government power as well as the power of private sector companies. The more someone knows about us, the more power they can have over us. Personal data is used to make very important decisions in our lives, and in the wrong hands, personal data can be used to cause us great harm. Reasons why privacy matters. Limit on power. Privacy is limited on government power as well as the power of private sector companies. The more someone knows about us, the more power they can have over us. Personal data is used to make very important decisions in our lives. Personal data can be used to affect our reputation, and it can be used to influence our decisions and shape our behavior. It can be used as a tool to exercise control over us, and in the wrong hands, personal data can be used to cause us great harm. Respect for individuals. Privacy is about respecting individuals. If a person has a reasonable desire to keep something private, it is disrespectful to ignore that person wishes without a compelling reason to do so. Of course, a desire for privacy can conflict with important values, so privacy may not always be win out in the balance. Sometimes people's desires for privacy are just brushed aside because of a view that the harm is doing so is trivial. Even if this doesn't cause major injury, it demonstrates a lack of respect for that person. In a sense, it is saying, I care about my interest, but I don't care about yours. And we see this more often in everyday's activity. We have reputation management. Privacy enables people to manage their reputations. How we are safe, judged by others, affects our opportunities, friendship, and overall well-being. Although we cannot have complete control over our reputations, we must have some ability to protect our reputations from being unfairly harmed. Protecting reputation depends on protecting against not only falsehoods, but also certain truths. Knowing private details about people's lives doesn't necessarily lead to more accurate judgment about people. People judge badly, they judge in haste, they judge out of context, they judge without hearing the whole story, and they judge with hypocrisy. Privacy helps people protect themselves from these troublesome judgments. Maintaining appropriate social boundaries. Now with the social media going like skyrocket, we have all kinds of mismanagement and misprotection. People establish boundaries from others in society. These boundaries are both physical and informational. We need places of solitude to retreat to, places where we are free of the gaze of others in order to relax and feel at ease. We also establish informational boundaries, and we have an elaborate sense of these boundaries for the many different relationships we have. Privacy helps people manage these boundaries. Breaches of these boundaries can create awkward social situations and damage our relationships. Privacy is also helpful to reduce the social friction we encounter in life. Most people don't want everybody to know everything about them, hence the phrase none of your business, and sometimes we don't want to know everything about the others people, hence the phrase too much information. Privacy is built on trust. In relationships, whether personal, professional, and governmental or commercial, we depend upon trusting the other party. Breaches of confidentiality are breaches of that trust. In professional relationships, such as our relationship with doctors and lawyers, this trust is key to maintaining candor in the relationship. Likewise, we trust other people we interact with as well as the companies we do business with. When trust is breached in one relationship, that could make us more reluctant to trust in other relationships. The EU legal framework about GDPR and the European Commission. We have EU regulation, EU directives, EU decisions, EU recommendation, and EU opinion. Now we're moving into GDPR, the Global Data Protection Regulation in Europe, that is in a way connected to Qatar data protection and data privacy. They go together. The outline GDPR main requirement, GDPR sanctions, GDPR compliance, and data protection authorities inspections. Under GDPR, we have the chronology, entry into force GDPR May 24, 2016, coming into operation of GDPR May 25, 2018. 19 of October 2018, 400,000 penalty as sanction. First GDPR sanction came into life. The Portuguese Data Protection Authority fined a hospital for failure in comply with the confidential and security. January 21, 2019. Janvier is a French wording. It's connected here to the CNIL and Google. CNIL and Google are large corporation. Penalty 50 million euro. Highest sanction imposed under GDPR so far. Imposed by CNIL, failure to comply with transparency and information requirements. So it goes here, the GDPR chronology with penalties for the breaches. If breach happened, the penalty happened and enforced. GDPR scope, we have material scope of application. The principle is GDPR is applicable to the processing of personal data. GDPR doesn't apply to the processing of personal data carried out, A, in the context of an activity not falling within the scope of union law, B, by member state in the context of specific activity under Chapter 2 of Title 4 of the Treaty on EU, C, by a natural person in the course of a strictly personal and domestic activity, and D, by the competent authority for the purpose of preventing investigation, detection, prosecution, or enforcement of criminal offenses. So under GDPR scope, we have material scope of application. It goes likewise from A to B to C and to D. Under same scope, we have territorial scope of application. GDPR applies to the processing of personal data in the context of the activities of an establishment of a controller or a processor in the EU Union. Now, regardless whether the processing takes place in the EU or not, it applies. GDPR applies to the processing of personal data of data subjects who are in the Union by a controlling or processor not established in the Union, where the processing activity are related to the offering of goods or services, or monitoring of their behavior as far as their behavior takes place within the EU Union. The main definitions under Article 4 of the GDPR: personal data is any information relating to natural person, identified or identifiable data subject directly or indirectly. Concerns on any natural person, employees, customers, prospects, services provider, suppliers, subcontractors, etc. Examples: surname, first name, date of birth, home address, tax address, bank identity, employment status, example given: surname, first name, date of birth, home address, tax address, bank identity, employment status, income, assets, connection logs, IP address, employee number, photographs, and etc. Same Article 4 speaks about processing of personal data. Any operation or set of operation which is performed on personal data or on sets of personal data, whether or not by automated means, such as collection, recording, organization, structuring, storage, adaptation, or alteration, the retrieval, consultation, use, disclosures by transmission, dissemination, or otherwise making available, alignment, or combination, restriction, erasure, or destruction. Example: contact management, IT authorization and resources, external communication, elections, control of the use of information system, and etc. GDPR fundamental principle: 5 principles to comply with. 1. Process personal data for a specific legitimate purpose. 2. Collect strictly necessary and appropriate personal data for each purpose pursued. 3. Respect data subjects' rights. 4. Limit the retention period of personal data until the achievement of the intended purpose. And 5. Ensure physical security of premises, logical security of information and systems, and confidentiality of personal data. Lawfulness of processing activity under Article 6 of GDPR. Processing activity shall be lawful. Lawfulness might rely on data subject consent, performance of a contract, compliance with legal obligation, vital interest, public interest or exercise of official authority vested in the controller, legitimate interest pursued by the controller or by a third party. The GDPR obligations, we have obligation to comply with data breach notification, keeping of processing activity records, transparency, new definition of consent, privacy impact assessment, new rights for natural persons, sharing of responsibility between data controller and data processor, appointment of a data protection officer, accountability and privacy by design and by default. Those are the obligations to comply with under GDPR. Data subject right, GDPR provide for the following rights: right of access, right of rectification, right of erasure, right to restriction or of processing, right to data portability, right to object, right to define guidelines of the fate of personal data in the event of death, right to withdraw consent, and right to file a complaint to a supervisory authority. Data transfers outside the EU legal framework. Data transfers outside the EU are prohibited except where the following exceptions apply: adequate level of protection in the recipient country, appropriate guarantees, physical shield transfer to USA, standard contractual clauses, binding corporate rules called BCR, intercompany transfers, derogation provided by GDPR, example given, explicit consent to the envisaged transfer, processing necessary for important public interest purposes or for the safeguard of data subjects or other persons' vital interests. So data transfer, there's certain restriction and prohibition here as it applies with certain exceptions. Under GDPR, we have sanctions. On the sanction level, possible sanction, Article 83 of GDPR. Under this article, we have first category of violation, failure to comply with the obligation to process the data collected thirdly, processing of sensitive data, lack of information or consent of the data subjects, breaches of data subject rights of access, rectification, opposition, right to be forgotten, right of the portability of data to a third country, and non-compliance with the Data Protection Authority injunction. The fine applies here up to 4% of the annual worldwide turnover or 20 million euro. Second category of violations, failure to comply with the obligations to keep a register of data processing register, lack of notification of a security breach, failure to comply with the obligation of security, absence of privacy by design, absence of impact assessment, TIA, impact assessment, privacy impact assessment, failure to appoint a data protection officer, DPO. The fine up to 2% of the annual worldwide turnover or 10 million euros. The investigation started, first penalties, January 21st, 2019, 50 million euro fine and publication of the penalty by the French Data Protection Authority called CNIL. Failure to comply with transparency and information requirement and the obligation to have a legal basis for the processing of advertising personalization. The highest sanction so far to be put in perspective with Google's annual turnover in 2017 was 96 million euro. The penalty is equivalent circa 5% of Google annual income. June 12, 2019, more than 250,000 euro fine imposed by the Spain Data Protection Authority, called AEPD, violation of Article 5.1 of the GDPR requiring that data be processed lawfully, fairly, and in transparent manner, recording of the surrounding of applicant users, inadequate level of notification. June 6, 2019, 400,000 euro fine and publication of penalty by French CNIL. Failure to comply with the obligation to secure personal data under Article 32 of GDPR and with the data minimization principle, rental conditions, document freely accessible without prior authentication and stored without limitation beyond the period necessary for allocating accommodation free on real estate sector. So those were certain investigation going on in the breach of GDPR, the chronology from 2019 January to 2017 for Google. Also in June 2019, penalties range between 250,000 to 400,000 between a couple of countries. Failure to comply with obligation, failure to comply with transparency, failure to comply with requiring data be processed lawfully and fairly, and the recording of the surrounding applicant users in inadequate level of notification. All those breaches will give us how far the people are protected now for breach of personal data. Now, May 8, 2019, 170,000 euro fine imposed by Norwegian Data Protection Authority called Data Lawfulness. Lack of appropriate security measures of the computer file system, violation Article 5.4 and 32 of GDPR, file with login credentials for 35,000 students and employees found in public storage area. March 3, 2019, 220,000 euro fined by the Polish Personal Data Protection Officer, along with the accompanying order to properly notify data subject within 6 months. The failure to comply with the obligation to issue information notifications to data subject under Article 14 of GDPR. 2018, 50,000 euro fine imposed to an online bank by the Data Protection Commissioner of Berlin. Violation of Article 6 of GDPR requiring a legal basis for processing unauthorized processing of personal data of all former customers in order to keep a blacklist. When there's a violation, there's a penalty imposed. One year on, after the GDPR came to light, data protection authorities' behavior, first few months following May 25, 18, exploratory period, data protection authorities published recommendations and guidance to help companies comply with the GDPR, flexibility of authorities. As of now, this phase is over. Authorities are strengthening enforcement and applying sanctions less leniently. Risk of fines, example given, imposed on internet giants. Just a minute, please. As of now, the phase is over. Authorities are strengthening enforcement and applying sanctions less leniently. Risk of fines, example given, fines imposed on internet giants. Risk of temporary or permanent suspensions of processing, impact on the reputation of companies. Impact of reputation of companies. Now, data protection authorities' behavior influence for GDPR on other global legislation outside the EU. Many countries have aligned their data protection legislation or regulation with GDPR. Example given: Switzerland, Norway, Iceland, Liechtenstein. Regulation influenced by GDPR, Brazil and California data protection laws coming into force in 2020. Common requirement: data subject rights, data breaches and accountability or obligations. The European Data Protection Board has started to publish information for national authorities on its website. Data protection inspection. Now, before going further, any question to be posed? You have any question to ask, please?
Yes, Mr. Bashir.
Yes.
Hi. I saw a slide right in the beginning of the presentation, which said that data protection for children's data, there is no age limit.
We'll
Oh,
go
this is,
back.
yeah. I mean, this was way before, I think. It said that there is no age limit, and then there was something about 13 to 16 years old. So I did not quite understand what does that mean.
Yes.
Yeah, that one.
Right. Yes.
Yeah.
Now it says here under the website, no age limit 13 to 16 years old. So the law has a weak point here. They did provide age limit between 13 and 16 because under 13, use of internet is not so advanced by children, right?
Yeah.
So between 13 and 16, children start to use internet, to their mobile and so on. So that's why the law stipulated what exactly? It stipulated this: obtain parent guardian consent to processing child data, right?
Yeah.
Comply with parent guardian request for information or to remove, erase or cease processing if requested by parent guardian. Now, in certain areas, certain children breach the law, breach the regulation without knowing it. That's why with no age limit, parents is a must to, or guardian is a must to put certain restriction here and there for the interest of the child.
Okay, and what is this about 13 to 16 years old? So they don't require a parent's consent?
No, it requires parents' consent because under this sensitive age, parents' consent is still required because after 16 years old, the child will have liberty to choose whatever he likes.
Oh, I see. Okay.
So between 13 and 16 and below age
Okay,
of
understood.
13, parent interveners or guardian for sensitive data is a must to safeguard the interest, like participation in games, prizes. Nowadays, you can see in the application more games, war games, and games of something sophisticated that harm the child way of thinking and way of establishing friends and communication with other parties. How far
Okay,
the
so
parents are,
16,
sorry?
16 and below. So that is the age limit according to the Qatar law or international global data
This
protection law?
according to the Qatar law. We are talking
Qatar
about the
law,
Qatar
okay.
law here, yeah. Because
Okay.
under this part is under data publication aware. We are talking about Article 9 and 2, 9.3 and 9.4 in the Qatari law.
Okay,
This is
understood.
Qatar's current legal framework, penal code, and so on. This
Thank
under the
you.
Qatari law, where we move forward to GDPR. Okay.
Okay, thank you.
Okay. You're most welcome. Moving forward. Data Protection Authorities inspections. There's certain typology of inspections. Different forms of inspection apply to both data controller and data processor, example given IT provider. Following inspections are performed by the French CNIL and are likely to be performed by other data protection authorities, although it is not necessarily the case. Online inspection carried out from the premises of the CNIL without the presence of the controller processor. Now, informing the person in charge by means of an online report or of finding. Purpose of the mission: verify the applicable data protection requirements are complied with and look for potential unlawful processing activity. Make sure in particular that the necessary formalities are carried out, records of processing activities, and privacy inspection assessment, impact assessment preparing, etc. The processing operations carried out correspond to those entered in the record search for concordance or discrepancy. The information technology and physical security measures are appropriate.
Bashir, I have a question.
Yes.
Actually, since we were talking about the data processing and also what about the data storage? What is the labor law in so what is the data protection law in Qatar addressing the issues of storing data in Qatar or outside? Like we have servers, some third party.
We said when we covered the Qatar, the law in Qatar says what? It goes for storage of personal data and sensitive data up to 5 years. But also we said here, just a minute. We said here about email and data protection.
Yeah.
The data protection law go up to 5 years, while in the email side, the law number 20 of 2019, record keeping and data storage go up to 10 years. And the law number 20 says what? That any other law which has certain measures for storage or recording or penalties less than the article specified in law number 20, primacy goes for law number 20 of 2019, which means fines imposed in law number 20 are higher than any other law, including data protection and data privacy. In law number 20, record keeping storage goes up to 10 years storage and the record keeping, and goes beyond 10 years in case there's suspicious activity of financial crime, that this suspicious activity filed to the Qatar FIU and the enforcement agencies, and the file is not closed. While under data protection and privacy law, storage go up only to 5 years, and after 5 years, certain information should be erased.
Yeah, but it does not specify anything on the location of the data storage inside Qatar or outside Qatar.
No, but now most of the companies, as you may know, going into cloud, right?
Yeah.
So the cloud storage, there's certain rules and regulation in Qatar, and so whether onshore or offshore, put restriction how to store in cloud, the third-party risk, and you want to go into this area to store information or not. On regulation side, regulatory side, a sensitive area to store with third-party cloud without knowing the risk, how this information can be used. I'll give you an example. While I was, you can hear my voice?
Yeah, I can.
Yeah, okay. A couple of years ago, I was giving consultation to insurance broker in Qatar under QFC system, and found out that they have stored data in the cloud with another third party. When I went into deep investigation and verification, we found out that this insurance broker didn't take into consideration risk associated with filing information with a cloud company. Because filing and storing with a third party, you have to take how far do you know that this third party will not use your information and data? What is security? From practical point of view, I will tell you something. My son is IT engineer.
Yeah.
Did 10 years working for certain contracting company in Qatar with Qatari DR and else, and he found and he advised that storing in the cloud without taking appropriate security measures, information can be misused. And he advised the people he's doing business with not to go into this arena without knowing who's handling this kind of information, kind of storage, how it is handled, how it can be accessible, is it easily accessible or not. We found at one time in 2011, there are certain banks are storing information outside Doha in Singapore in the cloud. And when the regulator wanted to have access to certain information, because he is allowed to have access if the bank in question is subject to investigation or inspection, the bank in question was facing problems with obtaining the data on time, because now the data is not under his full control, it's under the control of third party. And third party was reluctant to do complex issues to provide the bank data stored at their end with necessary information, while holding the storage at your own server will be much easier to provide the regulator with necessary requested info. So storage-wise, this is a complicated issue. People find it more easy to go into the cloud, record everything in the cloud, you can save money, no server, nothing at all. But how far you can collect it, what the risk associated, and reputation of third party, because in this kind of life we are doing business now, when someone leave his house, he put a mask on his face. And when he goes back to his home, he take out the mask and put another mask.
Yeah.
And women can know it easily, right, Molly? Right?
Yes.
Yeah.
Right.
Yeah. So now, because of this mask going on and so on, so what we are talking about exactly, how far do you want to protect your information and personal data? So here we are talking about typology of inspection. Moving forward, purpose of the mission that was conducted here, different form of inspection. Online inspection carried out for premises of the CNIL without the presence of the data controller processor, informing the person in charge by means of online report findings. And the purpose of the mission was verify the applicable data protection requirements are complied with, and look for potential unlawful processing activity. What this mission here answers your question, my friend, how far this data protection and storage are complied with, and for the potential unlawful processing activity. Make sure in particular that the necessary formalities are carried out, records of
അയ്യോ
processing.
അടുത്ത് എത്തത്തില്ലല്ലോ 11:30 കഴിഞ്ഞിട്ട് എത്തണ്ടെന്ന് പറഞ്ഞിട്ടുണ്ട്.
You are talking to me?
അല്ല 11:25 എത്തത്തില്ല. വില്ലേജ് ഇവിടെ അടുത്താണ്.
Molly, what's up? Okay, make sure in particular that the necessary formalities are carried out, records of processing activities, privacy impact assessment, preparing, etc. The processing operation carried out on correspondent to those entered in the record, search for concordance and discrepancy, and the information technology and physical security measures are appropriate. Powers of person authorized to carry out inspection request access to all documents necessary to fulfill their mission, regardless of the medium, and take a copy of them. Now, collect on the spot or upon convocation and any useful information or justification, access software, program, and data, and the request their transmission by any appropriate processing in the documents directly usable for the purpose of the inspection. Now here, those powers for authorized person to carry out inspection or supervision, there's inspection perimeter somewhere, regardless of the medium, and to take copies. So copies collected information and else only for the purpose of inspection. They cannot be used. Now, inspection, when it's done, the supervision team will send a document, a letter to the party concerned, specifying what to be inspected, what to be asked, what kind of information should be available, and the task of inspection and supervision will be limited to this task. So any document provided will be provided under supervision task done by inspectors. You have a duty to cooperate. Data controllers cannot object the authority or its agent action, which means any company in Qatar or EU is authorized to do business licensed by one authority or another. When they are licensed, they have put certain restrictions, certain activity to operate with, and certain regulatory rules to follow the licensed party. So this is the duty to cooperate. Data controller cannot object the authority or its agent action. They must take all useful measures to facilitate the work of the authority. Which means if the authority, the inspector, comes to your premises and with a task he advised you in advance, and you were not cooperative of providing necessary information requested, then there will be in a breach of regulations and in breach of supervisory authorities, and will be here the data controller will be subject to certain penalty because they are not cooperative with the authority in question. The exceptions of professional secrecy, the right to the person in charge to object to the visit of the authority. The objection must not constitute an offense of obstruction. So with this kind of restriction, exception, should read the law in details where the certain exception is mentioned and act based on this exception, word by word. Potential follow-up of the inspection, we have request for additional information. We have denunciation to the public prosecutor, formal notice to cease breaches, online inspection, new on-site inspection, closing of the case with potential recommendation, and following the inspection. So this process, potential follow-up of the inspection, goes from one area to another, formal notice to cease the breaches when there's a breach, denunciation of the public prosecutor, always should have a request for additional information. Without any formal request, there's no inspection. The inspection goes beyond, and this is not recommended. Closing the case with potential recommendation. You cannot close a case subject to inspection without recommendation. And new on-site inspection. Now we are doing webinars online. Why? Because there's certain condition here prohibit us from doing face-to-face. Inspection-wise is done now, could be on-site, could be off-site. Online inspection or on-site inspection, depending on the case and the conditions. The inspection control by European cooperation and increased severity in order to ensure homogeneous and consistent protection of personal data throughout the EU. All European data protection authorities continue to cooperate. Example, collaboration on cross-border processing via joint control operations. The European cooperation here, the increased severity, particular attention will be paid to compliance of major groups and internet giants. Refusal of the name and shame principle. And you all know what's going on in Europe with Google, how the conflict of interest is going on, and how Google sometimes they refuse to cooperate. Let's say we have the Facebook issue. So penalties are imposed on Facebook, the Twitter, the Instagram, all the social media are subject to inspection because they are sometimes go in a breach of data protection and privacy laws, and whether in Europe or outside Europe. Sanction made public must not have the effect of disparaging company, but rather for them to draw lessons on the protection of personal data. Examples of supervisory authorities inspection powers in Europe. We have by country, we have France, Germany, Ireland, and UK. Power to make on-site inspection and done rates. In France, yes, and rates have occurred. In Germany, yes, no rates have occurred yet. In Ireland, yes, the power to make on-site inspection is allowed. In UK, in very limited circumstances, no rates have been occurred yet. Power to take copies of documentation during the raid. In France, it's yes. Germany, yes. Ireland, yes. In UK, in very limited circumstances. Power to seize document and equipment. In France is not authorized. In Germany, no. In Ireland, yes. In UK, in very limited circumstances. Power to carry out forensic investigation. In France, it's allowed. Germany, unlikely. Ireland, unclear. UK, in very limited circumstances. The British always so diplomatic, using vague way of expression. In very limited circumstances, you can analyze it the way you like it. Power to carry out other types of investigation. In France, yes, the request for a brief hearing online inspection of document is allowed. The power is here is allowed. In Germany, nothing clear. In Ireland, yes, request for hearing, inspection of document is allowed. In UK, yes, inspection of document, request of hearing is allowed. Now, highest fine for breaches of GDPR data protection laws. In France, 50 million euro, Google fine. In Germany, 20,000 euro, Kindles D. In Ireland, 45,000 euro. In UK, no GDPR fine yet. GDPR compliance checklist for mobile application developers. Determine what data is necessary for your business. Take advantage of open protocol like codes. Encrypt data from contact us forms. Take user permission before any type of tracking. Encrypt the logs. Prompt the user to read the terms and conditions. Do not store data of deleted users. Inform users about any data breach. Encrypt data. Use HTTPS for secure communications. Inform about cookies. Inform users about logs. Do not use personal components in security questions. Let users know about your data sharing policy and inform users about any data breach. Any questions? Any question, please?
Thank you for the wonderful session. Actually, all the points you covered. I had a session with our academy, GSC Corporate Academy. All our staff are actually were asked to take this course, GDPR. But there were so many points which we didn't get in our lessons actually. It's really wonderful. And the information and the details what you send to us, we will keep it in our files, and we will we are actually we are implementing all these things because compliance to 100% policies and regulations, our company will follow everything. But one simple question, maybe it's a foolish question. Do you think, or should we think, all the staff in all the companies are required to follow this, whoever works in Qatar?
Sure. Tell you what, all your staff, when they are doing online search on Google or else, or opening a website, whatever the case is, a pop up about cookies, say, do you accept or not accept? This pop up about you accept cookies or not is part of the data protection, sensitive data, and so on. So now, yes.
Yeah, usually because from our headquarters, if somebody is sending the director's passport copy or any other information like insurance payment for any staff or anything, they will send the document in with a protected password, and then they will send the password without the same subject on the top. They will send the password in another email. Usually we follow such things actually, because
because the password is generated like this by a system. Okay, and this is for protection issues. They are sending the password. You can create a password, temporary password, and later on you can change the password, as you know, to have more secure password. When you are doing your own password, the system will tell you we need more complicated password. You can use the upper and level and certain requirement to have more secure password. Because in the past, as you may know, everyone on the globe was having password 1, 2, 3, 4, 5, 6, 7, 8. This is what. It was so easy for everyone doing this because nobody cared, nobody had information about data protection, the privacy laws, and so on. By time, more hacking happening to website, to emails, and so on. Also, there's another area here I would like to highlight. A couple of years ago, in 2015, I believe, I was delivering a course in Bangalore about trade-based money laundering, 5 days course in Bangalore. Most of the attendees came from Bangladesh Bank, the central bank. Central bank was subject to a hacker who stole, this hacker overnight uh, went into the system of Bangladesh Bank and sent instructions to be processed through New York clearinghouse and managed to get $81 million. What happened, because the system in the automated system in New York, the correspondent found that certain spelling is not right spelling, they stopped certain transaction. Now, while doing my course presentation, the general manager of the IT of Bangladesh Bank was present, and he said, "Look, Mr. Nakib, this is the fault of the American. They didn't stop everything." I said, "What? My friend, your bank, the Central Bank of Bangladesh, failed to renew the firewall before the end of the contract. As a bank, as a company, you have a firewall to protect all the information on your website, on your system. If you take your time negotiating and time goes on without noticing what's going on, hackers are waiting in the corner on the cloud, and they are monitoring every single breach or weaknesses in Bangladesh and Qatar and Sri Lanka and elsewhere. And you can see nowadays the Christmas days, the holiday days, the end of the year, we can see a lot of breaches, a lot of hackers attacking malls, attacking companies, attacking Visa, attacking MasterCard. Uh, why? Because certain people do not pay attention to security measures over one area or another. That's why those data protection and data privacy, it must be available to everyone in your company, so everyone knows the the, the rules, the regulation, and if needed, we can provide more info, because time limit here for this webinar is 2 hours. If it was 3 hours or more, there will be would provide more information. But I would advise you, my friend, that I sent before this slide another slide document for about 89 slides, which has more information about other areas to tell you what I'm talking about here. Let me open this. This one. I provided an earlier version. Let me open it. since we have still more time, we can do.
Bashir, we can't see your screen. You have to share it again.
Yeah,
The new one.
yes, just a minute, my friend. Okay, now you are showing data protection impact assessment. You can see it. You can see the slide.
Yeah.
Yes.
Yes, this was part of my presentation, but I took it out because time limit constraint. In Europe, we have Europass. Europass is about data protection impact assessment. It's done. We have background identifying needs of data protection, data privacy impact assessment. Article 35, General Data Protection Regulation, GDPR, in particular with Article 39 of regulation, new technologies may carry high risk to the rights of the freedom of the individual. In case of processing on a large scale of special categories of personal data, and in cases of systematic and extensive evaluation of personal aspects based on automated processing, including profiling. Which means here, in the background, the new Europass platform proposed processing will, under no circumstances, produce legal or quasi-legal effects, may result in significant decision made through automated means with regard to employment and educational opportunities, and initiative proposed to the end user, and process special category personal data which may directly or indirectly be uploaded by the end user related to racial, ethnic origin, political affiliation, religious or philosophical belief, trade union membership, and data concerning health or sexual orientation. Purpose of data protection impact assessment is outline proposed processing and identify prospective risk of the data. So propose mitigation and measures to prevent the possibility of personal data breaches and the breaches to the GDPR affecting the freedoms and the rights of the end user data subject. The methodology here for data protection impact assessment, what detailed questionnaire, who numerous parties involved in the creation of a new European platform, and why require detailed description of proposed processing, storage of personal data, envisaged transfers of personal data, technical measures, and prospective risk. So the answers are routinely clarified and expanded to the complexity of the proposed platform. The progress here, the completed tasks include identification of proposed processing, including collection, expected use, storage, deletion, and user access and control location, the third-party recipient of end user, personal data and processing by third party, the existence of automated decision-making and profiling, special categories for data subject, and lawful grounds for processing. And the ongoing tasks include identification of the risk associated with the proposed processing and completion of the risk analysis to fully identify all the risk propose adequate prevention measures. Now, the executive summary of the findings gathered to data includes description of the risk identified so far and appropriate measures to mitigate them. Now, appropriate measures are good. Why? Because the authorities set rules and regulations to to be implemented. Any breach to those rules and regulation, appropriate measures is recommended to mitigate those breaches. The risks and consequences here to identifying potential risks and consequences of the new Europass platform. There's the risk and consequences. Under the risks we have, let me enlarge this a bit. Under risk we have here willful attacks of the Europass platform or the data. Is the characters clear to you, or should enlarge it more? Okay.
100 or
the risk here.
The side is getting closed.
Yeah, but we'll move the cursor. But talking about the risk here, willful attacks on European platform of data stored within it, resulting in threats to confidentiality and integrity of end user personal data. This is what I have mentioned before to your colleague about the storage within cloud system and what are risks involved and so on. The human error attributable to end users and platform administrators may impact the confidentiality, integrity, and availability of personal data. Willful attack resulting in the deliberate alternation of end user information, as well as the abuse of access of privileges, which may result in the willful alteration, destruction, or dissemination of end user personal data. That's why we should pay attention to all those areas. Errors and intentional failures which may result in the threat to confidentiality, availability, and integrity of end users' personal data. Now, in your own firm, you may set guidelines, kind of manual to your employee to follow, kind of code of business, code of conduct on personal data and so on. This will be helpful for everyone as staff members to read and sign the manual as they have read and so on, and later on to provide certain awareness session for better understanding of their rights, what to be done, safe, not to be safe, confidentiality area, and so on. One example I give you, if one of your staff is working on his desktop or laptop and leave his chair, his location to go to have a cup of coffee or speak with someone else, and keep the screen without protection, because once he leaves his chair, immediately he should what do? Prevent access to his screen by anyone, even by his colleague or by his boss or by someone else. Leaving the screen open can be accessed by everyone. This is a breach of what? The company or the entity security, IT security, correct?
Yes.
Yeah. So
that's a great policy for IT security also.
Yes. Okay. That's why when you have those guidelines about data protection, privacy laws, and so on, into a manual highlighting causes, breaches, and so on, made available to everyone to read and understand what are the consequences, what are the penalties imposed for the breaches, will be helpful for you and will be helpful when supervisory, your company is subject to inspection. They will see that you have done your job, okay, properly and better than anyone else. I recall, my friend, that one day in January 2006, I visited a bank in Saudi Arabia, in Riyadh, called Saudi Hollandi Bank. I was paying a visit to a friend and went to see Saudi Hollandi Bank compliance. And while having a sipping coffee, a private banker came into the room, and he was furious that the counter clerk at the main branch refused to execute a transaction the private banker has achieved. The case is about a private banker saw an opportunity to buy shares from a customer who is looking for some liquidity. So this private banker had inside information about his shares going up in the market. Now, the code of ethics of this bank specified that this kind of transaction cannot be done because there's conflict of interest. Why? Because this private banker had inside information and he's doing business with a customer of the bank. This is prohibited in banking and also in other kind of companies, prohibited from a staff member to do business with certain customer for his own profit, because this conflict of interest between the company policy and procedure and the staff member going beyond policies and procedure to make a couple of bucks. So what I'm talking about here, the more we have rules and regulation put into force, the more make everyone happy, because you have risk and you have consequences. Under the consequences, risk to rights of freedom of the end user may vary in likelihood severity, leading to potential material and non-material damage, possible breaches of data subject to the right involving servers, and 7 consequences: possibility of identity theft or fraud, disseminating sensitive personal data contained within updated end user documentation, inability to exercise control over personal data, loss of confidentiality of personal data, damage to reputation, particularly if personal data is altered or edited, and potential abuse and dissemination of data belonging to vulnerable end users and minors. All those risks and areas and consequences to be taken into consideration in relation to what data protection and privacy laws. So on first recommendation, implementation of policies regarding IT security system, retention and purging of personal data breach management and reporting, regulation and contractual relationship with third party, having access to or receiving personal data, particularly with where recipients are located in third country, not subject to adequacy decision regarding the security of personal data processing. So the Europass data will be hosted infrastructure that is either operated by DigiDigit and hence meet DigiDigit's security standard, or third-party infrastructure. So with every single process we are doing, there's certain risk involved. That's why having this know-how, the culture for how to encounter those risks is very important in our life. This was initially my presentation, but I shortened the presentation to meet time frame. But I believe Malavan still have it, and one of the Malavan colleagues still have it. Let's forward it to them to have more info about what we are talking about. And if there's any need, you will need to ask any question, please do not hesitate to communicate with me through Malavan. He can provide my email to you, and I'm happy to answer all your queries. And this concludes today our session. We still have 2 minutes. Any question, more questions? So in the end of the presentation, we have my email, phone number, and Malavan phone number and contacts. Yes, you were asking the question?
Yeah, no. Tomorrow also we have session, no?
Tomorrow, yes, we have another session. Yes.
Oh.
Correct. Okay. Tomorrow we'll talk more. We'll provide more example, more case studies to learn from.
Okay. Session. It's very up to the situation. It's really very nice.
Yeah, we try to serve everyone in Doha because I love Qatar. I like Doha. Thank you, everyone. And this will end our session today. Thank you.
Thank you.
See you tomorrow.
Thank you very much. Have a good day to all of you. See
Same
you
you.
tomorrow.
Yeah, same as you. Take care.
Yeah. Thank you.